This video is for permanent residents who are afraid of getting deported during the incoming Trump administration. In this video, we're going to be talking about a few things that you can do to just err on the side of caution to help protect yourself. First of all, let me start by saying that permanent residents have a right to live in the US, to work in the US, and to travel in and out of the US. But there are some limitations on these things, especially that last one. So the last time Trump was president, during his first week in office, or something really close to when he was first inaugurated, he initiated a Muslim country ban that prevented people from entering the US from certain Muslim majority countries. And some of the people who were denied re-entry into the US were permanent residents. They had green cards. And a court quickly issued a decision saying that that's illegal. You cannot deny permanent residents from entering the US. They have an absolute right to enter the US as long as they are not inadmissible for crimes and other things. But most permanent residents have an absolute right to re-enter the United States, and they cannot just be denied entry by someone in the airport because they feel like it. Now, anyone less than a permanent resident, if you have a visa, even a student visa, if you have DACA, if you have TPS, and you're traveling with parole or something like that, or a tourist visa, you are never guaranteed entry back into the US. The government can actually prevent you from coming back. The customs officer in the airport can deny your application for entry. They could put you on a repatriation flight back to your home country, or even a third country if you aren't able to return back to your home country. So all of that is actually possible, but permanent residents have a right to re-enter the US. Now, there's some caveats here. If you leave the United States as a permanent resident for more than 1 year continuously, and you did not first apply for a re-entry document, which is a document that lets you leave the US for more than 1 year, you risk abandoning your permanent residence. And what happens is, when you come back, the customs officer in the airport will sometimes say something like, "You've been out of the US for more than a year. You've abandoned your residency. Come with me." They bring you to a back room. It's called secondary inspection. And they will sometimes try to get you to sign a form. I've mentioned this in another video that I'm posting this week. That form is I-407. It's for voluntary abandonment of your residency. Oftentimes they'll interview you. They want to see why you left the US for that long. And it turns out that if you intentionally left the US for more than a year, there's a good chance that you've abandoned your residency. If you refuse to sign that form, which I will generally advise that people do, at least until they speak with their attorney, I wouldn't sign that form. But if you refuse, there's a good chance that the customs officer will give you a notice to appear in immigration court. You'll be released into the United States, and then you need to show up to immigration court for a judge to determine whether or not you actually intended to spend that much time outside of the US. Let me give you an actual example of something that played out. So there was a permanent resident from Iran who lived in the US. He wanted to go back to Iran for a short period of time to attend a relative's funeral. I think it was his grandfather. Upon entering Iran, he was arrested and sent to prison for like 5 years for some random offense the Iranian regime claimed he committed. Upon being released, he immediately returned to the United States to continue his life here because his family was here, and he never intended to spend that much time outside of the United States. When he came back, the customs officers in the airport gave him a notice to appear in immigration court because they claimed that he had abandoned his residency. He goes to court, and an immigration judge determined that he did not intend to spend 1 year outside of the US or longer, that it was outside of his control. His intention was to permanently reside in the US during the last few years and never to depart the US for more than 1 year continuously, and therefore he continues to be a permanent resident, and he was able to keep his green card. Another thing to keep in mind is that there have been situations where departures of less than 1 year created problems for people as well. First of all, any departure exceeding 6 months, you can expect it to affect your timeline for US citizenship. You probably will be determined to not have continuously resided in the US for purposes of naturalization. So if you leave the US for more than 6 months, you can definitely expect it to affect your timeline for citizenship, how early you can apply for citizenship. But the other thing is, if you spend a lot of time outside of the US, let's say you go outside of the US for 5 months, come back for 2 weeks, leave again for 5 months, come back for 2 weeks, and you do this like 10 times in a row. Eventually, when you come back, you can still get sent to the back room to secondary inspection by the customs officer and questioned about why you're spending so much time outside of the US, because it certainly does not look like you're permanently living in the US. At that point, they can ask you, where are you working? Where are you living? Where are you receiving mail? Do you have car insurance? Do you have a rental agreement? Like, prove to us that you intend to physically live in the United States. And that's another way you can theoretically be placed into removal proceedings if you refuse to sign the I-407, which, again, I generally advise people to not sign until they speak with an immigration lawyer. So what's the takeaway here? Don't spend too much time outside of the US. If you're uncertain how much time is too much time, speak with an immigration lawyer, create a plan. The advice might be to bring certain evidence with you in case the customs officer gives you a hard time when you re-enter, or to limit your travel a little bit so that it's reasonable and so that it looks like you're physically living inside the United States. Another way to lose your permanent residence during the incoming Trump administration is for certain crimes. So historically, only certain types of crimes made you deportable. Other crimes made you inadmissible, which means you're not deportable, but if you end up traveling outside of the US, you won't be allowed back in. They won't allow you to re-enter the US. So if you've ever been convicted of any crime and you have a green card, speak with an immigration lawyer before you physically depart the US. There might be ways to fix it, such as by naturalizing, even though you're not allowed to re-enter the US and you're inadmissible. There's a bunch of loopholes here, so speak with an immigration lawyer before you travel internationally if you've ever been convicted of a crime. I've also heard other things like certain crimes that historically were strict liability, which means they did not require you to intend to commit the crime, such as simple DUI. So simple DUI does not require you to intend to be drunk in most jurisdictions. Here in New York, simple misdemeanor DUI, your first offense generally, you just need to be in the car with the keys in the ignition and your blood alcohol content is above a certain amount. You don't even need to be physically driving. You don't need to intend to be drunk. Theoretically, a cop could pull you over while you're sober, and by the time the cop walks up to your car, someone can inject you in the neck with alcohol, and now you're DUI, even though you didn't intend to be. Your intent is not relevant with a strict liability offense. But I've heard, and this is pure speculation at this point, that there's going to be a push for DUIs to also create risks of deportation from the United States. So the big question becomes, is that going to be applied future looking or retroactively and applied to previous DUIs? There's a presumption under the law that it will not be applied retroactively, but there have been other times in immigration law history when new changes, sweeping changes, have been applied retroactively. So that's yet to be seen. The final thing that I want to mention is that the naturalization process is going to become much stricter under the incoming Trump administration. If his past administration teaches us anything about what he's going to do this time around, there's general consensus amongst immigration lawyers in the United States that the naturalization process is going to become more intense moving forward. So some of the changes that happened last time that we could expect to carry over into this administration are that there was an extreme vetting process when a permanent resident applied for US citizenship. This made processing times much longer, and it also increased the ways that an immigration officer can deny someone's citizenship. Interestingly, the percentage of applicants who successfully naturalized did not actually change from all of these new policies, but it created massive backlogs. For example, currently, we can see someone apply for naturalization and then 6 months later they are a full US citizen. But under the tail end of Trump's first term, there were some people waiting like 18 to 24 months in some cities to become US citizens. So that's a 4 times longer processing time than we're currently experiencing. When someone applies for naturalization, USCIS is going to do a really intense background check to make sure they didn't improperly become a permanent resident and that they're eligible for naturalization. If they find something that's super derogatory, then there are some instances where they could place you into removal proceedings. If they find that you became a permanent resident through fraud or intentional misrepresentation is a good example. And it also, in some instances, depends how long ago you became a permanent resident. So just suffice it to say that you should at least do a Freedom of Information Act request before you apply for naturalization to get a complete copy of your immigration file. In most situations, if your case is super clean and you already have a copy of every document that was submitted when you applied for permanent residence, then there might be instances where I say like, okay, we don't need to do a background check, we don't need to do a FOIA request. But to play it safe, I would prefer to do a FOIA request for anyone who wants to apply for citizenship, unless you have time restraints or you want to apply ASAP and you don't want to wait a few months for your background check to come back. But checking your background will sometimes help us avoid paying unnecessary filing fees. It might avoid getting your naturalization application denied unnecessarily. And in rare and extreme situations, it might even prevent you from getting deported if you were improperly granted permanent residence to begin with. All right, guys, that brings us to the end of today's video. Those are 3 ways that you can help protect yourself if you're a permanent resident. But just remember, as a permanent resident, you have a right to live in the United States, so don't be afraid. The people who should be most afraid are people who are unlawfully present in the US, people with serious criminal history, and people with active removal orders. I think those are going to be the top priorities. Legal immigrants who are here lawfully as lawful permanent residents have much less to fear. If you have any questions, feel free to schedule a consultation. I represent people in family-based immigration cases like marriage-based green cards, naturalization, and we also do some removal defense litigation. If you have any questions, throw them in the comments below or reach out directly, and I'll see you guys next time for another video.